Hi everyone, welcome to Legal Talks by Desi Kanoon. I am Suyash and I am excited to have started this show. On today's show, we will discuss the case of Vice Chancellor Anand Agriculture University versus Kanubhai, Nanubhai, Vaghela and another, wherein the Hon'ble Supreme Court discussed whether the daily wagers are entitled for regularization of their services. Briefly speaking, the appellant university engaged daily workers who raised a dispute seeking regularization of their services. The matter first reached the industrial tribunal that ordered the appellant to regularize the services of daily wagers who have completed 10 years of service. Thereafter, the matter traversed to the High Court of Gujarat that directed to make payment to daily wagers at the minimum pay scale and frame a scheme for regularization of such workers. The appellant university appealed against such order before the Supreme Court that passed the judgment dated 18th of January 2001 in the case of Gujarat Agricultural University versus Rathod Labhu Bechar and others. It approved the scheme of regularization framed by the appellant and directed the appellant to create additional posts and absorb the daily wagers within 6 months. However, somehow that regularization process could not get completed and the daily wagers again approached the High Court. The High Court allowed the plea of daily wagers by judgment dated 13th of March 2018 and again directed the respondents to treat daily wagers as permanent employees from the date they have completed 10 years of service as daily wagers. Thus, the appellant university again approached the Supreme Court claiming financial difficulties and other such grounds. Now let us understand the pertinent observations by the court. Firstly, the court distinguished the case of Secretary, State of Karnataka and others versus Uma Devi and others that was cited by the appellants, wherein it was held that regularization of services as a one-time measure can be done only for those workers who have worked for more than 10 years in duly sanctioned posts. In this case, the court observed that the case of the respondent daily wagers is already covered by Gujarat Agricultural University versus Rathod Labhu Bechar case, and the Uma Devi case will not have any effect on such order. Secondly, the court observed that regularization of services needs to be made in a phased manner, and there should be creation of additional posts in an expeditious manner. Thirdly, the court noted that the plea of the appellant university is that only 890 posts were created for regularization, and since no further posts have been created, regularization of leftover daily wagers is not possible. The Honorable Court was not impressed with such plea and observed that when 890 posts can be created in compliance of the 2001 Gujarat Agriculture University judgment, then the leftover daily wagers are also entitled for regularization, and it is the obligation of the university to implement its regularization scheme to cover such leftover eligible daily wagers. Therefore, in light of the above, the Honorable Supreme Court held that there is no error in the judgment of the High Court which warrants interference, and the eligible daily wagers have a right for regularization. That was all about the case. So what are my concluding remarks? I concur with the underlying reasoning of the court that when an earlier order has been passed by the Supreme Court, it must be complied with. And the excuse that the rules of regularization have changed after such judgment cannot be claimed by the state. It is truly a pity that many daily wagers who were seeking regular daily wagers get their regularization as soon as possible. Hence, I hope you enjoyed listening to this show. Thank you for listening. Please do not forget to like and subscribe us. And if you have any comments, please make them in the comments section. See you next time. Till then, stay tuned.